The Constitutional Court will today hear the suspended public protector's bid to return to office with immediate effect. In her court papers, Mkhwebane is arguing that the final year of her 7-year term began last month and returning to office would ensure a smooth handover to her successor. Let's speak now to legal expert Khumisi Kganare, who joins us via the virtual platform. Mr. Kganare, thank you very much for your time. 3 areas I'd like to explore with you. Let's start with the decision by the President to suspend Advocate Busisiwe Mkhwebane on the eve, if you like, of her investigations of the Phala saga. Do you think that the court will likely affirm the decision of the Western Cape High Court, which said that this decision was invalid and therefore set aside?
Good morning, Dolly, and thank you very much for the invite, and good morning also to the viewers of Newzroom Afrika. Yes, I mean, that's the main question really this morning that's, facing the Constitutional Court, whether the order of the High Court declaring the President's decision invalid and setting aside the public protector's suspension is subject to confirmation by the Constitutional Court. So when you have a look at the the order that came from the High Court in Western Cape,
Mr. Kganare?
Conduct.
Sorry, you
can you hear me, colleague?
You broke off for a moment there. Please continue.
Okay, my apologies. Yes, and I was saying that's the main question really facing the the Apex Court this morning, amongst other issues that it needs to deal with, whether or not the order of the High Court declaring the President's decision to suspend the public protector invalid and setting it aside. That what came out very strongly from the High Court in the Western Cape is, look, the Constitution, insofar as it relates to the conduct of the President, especially in circumstances like this one, is that there has to be a way between the President's official responsibilities and his personal interests, and I mean that's one of the reasons mainly why the High Court came to a conclusion that the President's conduct, suspending the public protector immediately after knowing of the investigation against him. Maybe if the decision was to suspend the public protector was made before this, it could have been something else. But for the fact that it came immediately after knowing of the investigation that the PP is carrying out against him, that constituted a big issue for him.
Another area of consideration by the Constitutional Court justices, Mr. Kganare, is going to be whether or not this decision was motivated by personal bias. And it's a very area you have just explored, that this was on the eve of the public protector possibly investigating Mr. Ramaphosa on the Phala saga. But the question I have for you is, for the judges in the Constitutional Court to come to a determination around this, what analytical tools do they employ to assess whether this was motivated by personal bias?
I mean, first and foremost, the standard that is applied, in processes of this nature, because I mean, this is not a criminal, law process. We're talking here, a civil, process, and it's on a balance of probabilities. And I mean, that's something again that the High Court said on the balance of probabilities. I mean, it can be assumed, it's justified to assume that the President's decision to suspend the public protector was motivated by, the investigation against him in relation to the Phala issue. So on a balance of probabilities, that's what the the Constitutional Court will have to have a look into. That the suspension, what is it that is that surrounds the decision that was taken by the President in suspending the public protector. And also, again, it doesn't take away, the fact that the High Court is entitled to pronounce on constitutional, validity, be it of the National Act of Parliament or a provincial act. It also, includes the conduct of the president.
Mm.
So that's something that, the Constitutional Court will have to either confirm because, confirm, even though the High Court has powers to, declare invalidity or validity of, an act of parliament, president's conduct, but it has to be confirmed by the Constitutional Court at the end of the day.
Sure. Let's conclude the conversation then with the third area, and that is the immediate return to office. That is something that she has made quite clear, that she wants to return to office with immediate effect. She's even gone to court. Unfortunately, she has not been successful there. Again, do the judges say, well, Western Cape High Court, you were probably correct in saying the president acted in bad faith here, so to speak. Not only do you return to office, but your suspension is set aside.
Yes, mainly that's what was the outcome of the High Court in the Western Cape, that the suspension be declared invalid, unconstitutional, and as a result, it has to be uplifted. Essentially meaning that the public protector will have to go back to office. If the Constitutional Court deems it fit while dealing with the issues, they can also, but it's something that the public protector did not necessarily request, that in the interim, she be allowed to go back to work. But effectively, the fact that we are now, going through this process, that whole thing is, kept in abeyance until the Constitutional Court decides on the issue.
Here's a final question. We all know about the doctrine of separation of powers, the three arms of the state. So at the moment, we're dealing with the judiciary. There is the legislative process. The legislative process is what is going on in Parliament. That's the Section 194 matter, which is determining whether or not she is fit to hold office. Do you foresee the ConCourt making that a consideration at all, to say we can't make a determination here just yet up until that matter is concluded? Or do you think that the court is simply going to deal with what's before it?
I think the court will highly likely separate the issues because when we have a look at what is happening now insofar as the suspension is concerned, it has got nothing really to do with the process that is underway, in terms of Section 194. And a determination will be made on the suspension, and there is no question really about, the Section 194 process. If anything, the Constitutional Court made it very clear, I think in February this year, insofar as that process is concerned, because you would remember that previously Parliament did not necessarily have the rules that deal with these sort of issues. But now it does, and the Constitutional Court has also confirmed, to some extent, even amended some of the rules insofar as they relate to legal representation. So there are no issues. I'm sure they will not, convolute the issues insofar as they relate to the Section 194 inquiry, because this is something else really.
Khumisi, Kganare, let me thank you very much for your legal analysis on this matter. Thanks indeed for your time.